Hey guys, it's Gary. Going to talk about the contract termination fee. As we mentioned last week in our legal tip, South Carolina Realtor Association has a brand new contract out, which I'm very happy about. I'm happy to see that's out there. They have a termination fee in there for the due diligence. I did mention last week that I am not a big fan of termination fees for due diligence. My position was I shouldn't have to pay you to look at your house to determine whether, in fact, you lied on the seller disclosure or whether you even did the investigation to find out your house was, in fact, a rat trap. So I don't think I should have to pay for one. But in all fairness, there is another argument on the other side as to why termination fees might be necessary. And so since my job here is to present you all the sides and then let you decide for yourself which you like, I wanted to present the other side. And I got lots of great emails from lots of great people on both sides of the argument throughout the state saying they liked it, they didn't like it, and so forth. So I wanted to hit on some of the main arguments for those who did like the termination fee. And so we can discuss that. Number one reason that people said they liked it was because it does give another way to separate their buyer's offer from somebody else's offer. So if all offers are the same in terms of value, we both offer $300,000. If somebody's offering a $5,000 termination fee, that shows they're more likely to stay in the transaction and work through the issues than bail. So I think that's a valid point. Number two, if you have a seller who is concealing property conditions, there is a belief that that would actually bring you outside of the contract because that might be a breach of the contract for failure to disclose. Now, of course, the person who sent me this even concedes that that's kind of a difficult thing to show. If the person clearly knew about it and failed to disclose it, that would be a breach of the contract. But they did concede that it's often they're going to say they didn't know about it or couldn't know about it. And so it wasn't a failure to disclose. Nobody wants to hire a lawyer for arguing that. But that is something that if the person clearly concealed, let's say, foundation issues with the property or a leak that they clearly knew about and they've been just patching it, that would be a default issue, and that would probably mean the buyer doesn't have to pay the termination fee to get out of the contract. There also is the statement that you can put zero. So if you are a buyer who's just 100% opposed to it, you don't have to use it. You can put zero for the termination fee if you want to. And based on what somebody at the association said, they said that was kind of in a regular market. That's what they typically see is zero. So don't be afraid or shy to use zero if your client says, I don't want to pay the termination fee. They don't have to pay it. If they want to put $0 or $5 or $10, that's perfectly fine. There's also an argument that this termination fee will stop the buyer who tries to tie up the house. During this hot market, we've had buyers who would simply sign a contract. During the due diligence period, they're continuing to look for other houses. If they find a better house, then they cancel this contract. That would stop that. That might be true in this market. I think we're heading out of this market. I think we're going to hopefully get back to a more buyer-seller equal market, and I'm not sure how much we'll need that at that point. But we have seen that quite a bit over the last year. And then lastly, we believe, or the person believes, it could avoid some of the earnest money disputes that we've seen. Because if the seller is getting a termination fee, they may be willing just to let the earnest money go because at least they're getting some money, and there may be some validity to that argument as well. So that would be those would be the arguments on the termination fee. The other issue that the association wanted me to touch on is that the wood infestation section can be part of the due diligence or outside the due diligence. It depends on how the dates you use on the blanks. And the reason they do like it is a lot of times you want to get your due diligence done in 5 to 10 days, but the termite letter for some lenders can't be more than 30 days old. So they can go ahead and knock out the due diligence for everything else and still have the CL 100 issue handled as we get a little bit closer to contracts, as we're starting to see more and more contracts go beyond 30 days to be 45 days and 60 days because of just the inability to get the loans processed because of what's being required of the lenders today. So hopefully that will give you all the counter argument to the termination fee. Again, I'm not a fan of it. Doesn't mean I'm right or wrong, though my whole mantra is often opinionated, rarely wrong. I'll take that for what it's worth. But I do think they have made some valid arguments on the other side. So I wanted to present those arguments from the association. Some people I talked to the association and some people that are just real estate agents who have been involved in either the drafting of that or who are fans of it, and let you see their side as well. All right, y'all have a great weekend and come back and see us again next week for another legal tip.